Hi, this is my second video for my honors AJS project on Supreme Court cases that changed America. Um, this is the second case that I believe is most important. It is Terry v. Ohio, and it occurred in 1968. What's special about this case is that it's quite noteworthy in the fact that it kind of brings together a lot of I don't know what the word for it is, but it kind of situates, it kind of encompasses the general idea of search and seizure. It just kind of to me, it's symbolic. It's kind of I don't know if symbolic, but it's kind of the most intriguing in terms of being an example of the Fourth Amendment, which is unreasonable search and seizure. And it applies to a lot of these cases that were listed and stuff. I picked 5 of them, and this one is important because it kind of establishes what people believe is quite vague and cool. It has leaves a lot of room for too much, power, I guess, too much invasion of privacy, but we'll get into that. But I just want to explain that this case is, in particular, is noteworthy. Like I said, is because it deals with a lot of searching and seizure on the and whether that seizure and searching in particular is reasonable or if it's unconstitutional. So in this case, it occurred in the 60s like the other one, like Schimmel, and this one revolved around 3 men kind of, I guess, meandering around I guess, like, what is it, not a bank or something. It was, it was just kind of like an area. It was like kind of like an open area. It was kind of like in a very populated or something like that. I don't know. They were like an area where there were police officers around, and the police officer spotted these 3 guys, and they were kind of suspicious of them for some whatever reason, though. I guess the way of their movements or something like that. When they searched them, they found that 2 of the men had been possessing illegal weapons, and so they were, of course, arrested and convicted, and they went to trial and stuff like that. But their firearms, they were, of course, illegal, and it was concealed, which in many states today, it's actually not illegal to carry a concealed weapon, if I'm not mistaken. I think in Arizona, it is legal to carry a concealed weapon, though I think it kind of depends on certain circumstances. I'm not even 100% sure, but I don't think it's illegal to, maybe conceal it if you have it on you or something like that. Maybe not necessarily brandish it, but in this case in particular, it was illegal back then. But I guess the defendants argued that it wasn't reasonable and that the officers technically did not have probable cause. But the officers, believed that the men were dangerous and that they were a threat to public safety, which is why they took that action in the first place. But the thing about this case is that almost unanimously, the Supreme Court ruled in favor of the state of Ohio in terms of conviction. And so because of this, they implemented these stop and frisk laws, which are also known as Terry stops because of this, obviously, this case, Terry v. Ohio. The main suspect of this case involving the guy named John Terry. And so it's basically saying that under some circumstance, they can't, they can act on police officers can act on the basis where they believe, believe the crime is about to occur, or it has occurred, or it's in the process of occurring. And that right there is intriguing because not only does that leave up to an interpretation of the officer, but arguing this in court and stuff, what kind of sets something apart from, it being, I guess kind of overbearing or intrusive. How would they know? How do they know what a suspicious person looks like? How will they know? You could be walking awkwardly or loitering over there or something like that. But this case in particular, it generated a lot of controversy, especially in the modern era, where people believe that it unfairly targets minorities, or people kind of linger around in high crime areas, and that has, of course, started a lot of debate. But it is monumental in the fact that it's police can, you know, not apprehend you, but like briefly stop you and determine whether or not they have a probable cause to see if you have committed a crime or not, and they can do it without a search warrant. So it leaves a little bit of iffy room there whether or not the Fourth Amendment, should be considered because, I'm not going to get into this debate though, but what I will say, it is relevant in the fact that, you know, what could be suspicious, what could be interpreted as suspicious, how well, is it kind of walking a certain way, or is it kind of just doing something, that relies on interpretation of the officer though. So, it is kind of like, for a lot of people, it just kind of seems it's just kind of like a shortcut for police, where it's just a quick tool for just to detain someone for a moment, and stuff like that. But, as of right now, I guess in terms of how could it be applied, um, maybe, I guess in general, if you, because again, it's not relying on like, how society evolved with like technology and stuff like that, but like, what you could be doing, where you could be standing, where you could be walking, and if you could be going around and, I don't know, I guess, I don't know, just doing whatever, but there has to be some type of, where could one argue where one could kind of interpret probable cause without a warrant though, and that's kind of risky there because whether or not, because it kind of blurs the line between actual public safety or just for police to do their job, for them to do their job a lot easier and stuff like that. So that's just kind of, I guess that's kind of an interesting law there, but um, you know, I don't know, maybe in terms of like newer stuff, like maybe what if in technology, what if, if your phone rings and the police officer's like, let me see your phone, stuff like that, and stuff. I mean, obviously ring, but like, maybe if, if they believe you're associated with something, I'm not sure, but that's the thing. This is where I'm struggling to articulate my words because, it could, like I said, it could be interpreted any way, however, one would see it, So I'm kind of looking at this further. So, it kind of argues if this is excessive force or not and stuff like that, whether or not if it's overbearing, if it's intrusive, and, where and when can this be de-escalated and stuff like that into something where it's not privacy inducing or it's not incriminating, and whether or not something is actually conceived as a threat or not, So there you go.